A 35-year-old man with a 2-page-long criminal history stands before a judge, facing another felony charge. He's been in jail for 2 months on a $50,000 bond for forging a check. But this isn't just about a single $400 check. The judge lays out a decade of crime, from drug possession to evading arrest, and questions if this man will ever change. The defendant wants to take a plea deal, but the judge has a bigger question: how do you make someone finally take responsibility? This is the moment he's forced to confront his past and decide his future.
Here's everything. What's his bond right now?
Bond, and he says that he could make a bond where the fee would be $2,000, which means it would have to be reduced, I'm guessing, to $20,000 for him to be able to make that. Is that correct? Yes. You have to say it.
Yes.
You have to take down everything.
Yes.
50,000.
Well, your bond is right now at $50,000. So we go, why?
Yes.
This is a state jail felony, so.
Yes, sir. He's just informed me he would like to just move forward on the plea.
He has a right to. What's your final answer,
Please.
Jeremy? Because I'm about to look into the book, and here are the rules for fixing the amount of bond.
It's all right, Your Honor. I'll take the plea.
It sounds like you're not certain what you want to do. I'm looking at your criminal history, which is 2 pages long here. That's part of what is factored into in the amount of bond, as well as the circumstances of the crime. I also have the probable cause affidavit here, which states it looks like you allegedly forged a check in the amount of $400. You went in a do-good federal credit union to present the check for cash. You left the bank. Then the actual owner of the account called and said a box of checks had been stolen and several forged checks were being filed on his account. Intentionally or knowingly passing a forged writing, knowing that to be forged, purporting to be the act of another who owned the account, did not authorize the act. Then I have this copy of the check. It says to the order of Randall Hughes, $400. You pleaded guilty to evading arrest in 2017. Abandoning or endangering a child, 2017, a plea. Assault of a public servant, 2016, that was a plea. You got other arrests, but I'm just looking at the pleas. Illegal possession of a controlled substance in 2013. And then this forgery. Is there a loss of $400?
It's actually more than that, Judge. That's just the check that's represented in the charge. By my total, it's $2152.63. I'm doubling cross-checking that check.
2162.53.
$2152.63 is the number I had at this time, Judge.
52.63.
How long have you been in jail?
2 months, sir.
How's that working out for you? You enjoying it, or just
No,
you're not good?
No, sir.
Well, I'd be worried if you said I'm just enjoying the heck out of this. Where are you employed when you're not in jail?
I'm not.
You're looking over there, which means you're not employed,
No,
right?
sir.
Okay.
I'm gonna go ahead and take the plea, Your Honor.
No, I'm trying to. I want these people paid back. Somebody's lost money, and then it costs to house you. The taxpayers, we're just bleeding money with you. What you need to be doing is the right thing, not forging and stealing, but being independent and being a responsible person. But you hadn't been since early 2013. 10 years now. How old are you?
35.
Well, it's time to grow up and become an adult.
Your Honor.
I'm sorry. You say something don't interrupt the court. Don't interrupt the court, please. Thank you. He's a grown-up. No shouting, or you can leave and wait outside. That's the rules. This isn't people's court where people shout out things. We have order and That's why the bailiff is here. So how do you pay them back? I mean, we're out of money. I mean, somebody needs the money. Somebody's out money that you took.
That's your job.
Well, you sound like that's cruel and unusual punishment. Everybody should have a job, right?
Yes, sir.
What do you do when you're working?
Construction.
Are you good at it?
Yes, sir.
Would you have a job if you were placed on probation for some reason? Would
Yes,
you
sir.
have a job?
Yes, sir.
Where would you work?
Construction.
I mean, who with?
RCI.
Sir,
RCI.
they would hire you?
Yes, sir.
How much do you make an hour then?
$18 an hour.
That's 40 grand. That's enough to be independent. You have a family?
Yes, sir.
I mean, children?
Yes, sir.
You got children?
Have a son? Yeah.
He live with you?
No, sir.
Well, do you have somebody? Do you live with the mother of the child?
No, I live with my mother.
May I, Judge?
Yes. Go.
I want to amend the amount that I told you. There were 6 checks that were dealt with. 4 of them end up in Orange County. So the amount for the loss here in Jefferson County is $700.
It's just 700,
Yes, sir.
not 2,000.
The total loss to the victim is that number represented, but the other amount, 700 is the only proper amount in Jefferson County, Judge.
Okay. There's another amount lost in another county.
Yes, sir. Orange County is dealing with that. I don't want to
Do
double.
you have charges out of Orange County?
No, sir, I do not.
If,
That's what this indicates.
Do you know, Kevin?
no, all I know is that he may not be charged yet, but I don't know whether they're proceeding with it or not. Is that what you're getting?
That's what that
Impression that they are
indicates.
proceeding?
Yes, sir.
I don't know.
Okay, so
I'm only
final answer.
Final answer for me is
Yes.
$700.
$700.
Yes, sir.
I want those people paid back. How can you pay back $700?
Why'd you get that? Good job. I was on probation.
Does he have a final felony conviction?
He does, Judge. The last time he was convicted, he received 15 months state jail. That's why I went up incrementally.
Okay. So you're not eligible for probation in front of a jury. You are in front of the court, but I'm not sure. Because if they do something in Orange County, what good is it if you're on probation and having to do time in Orange County? Then you're doing your probation while in custody. That doesn't work. You're not representing him on anything in Orange County.
No, Your Honor.
Kevin, if you can
Yes, sir.
talk to the defendant and see what we're trying to do to fashion out a plan so everybody gets treated fair on this. I don't see how 18 months without paying back restitution does much. Since he was in, your last state jail was how long? 15 months? 15,
Sorry, I didn't realize.
50, you were in 15 months in state jail last time? You don't have a lot of bargaining potential here by getting back into a crime, you know. But anyway, they're talking about some things. So why don't you listen and see if there's something that you can work out. Let me know.
A few moments later.
And Mr. Peters still.
Your Honor, we ask that the court allow us to change the plea papers to reflect an agreement for the court to consider 2 years to do in the state jail, probated over 5 with a 90-day upfront sentence and $700 restitution.
Is that
Yes, sir.
what you wish?
Yes, sir.
Okay.
Thank you, John.
Okay, we called Harold Randall Hughes, 23 CR 1012. That's the defendant who's here with Ms. Manfredi. Waive a formal reading of the indictment and arraignment. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges, again, that on or about March 17th, 2023 in Jefferson County, Texas, you committed the state jail felony of forgery of a financial instrument. Do you understand what you're charged with?
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached here where you would be pleading guilty. What do you want me to say?
Sentenced to 2 years state jail, but the sentence suspended for 5 years, 90 days upfront time, $700 in restitution. And we would ask that the, what time he's got already in would go toward the upfront.
What's the restitution? Restitution again?
700.
You say $400?
700 restitution.
Is it the bank or buried?
The restitution,
Probably the bank, Judge. It's a DuPont, Federal Credit Union.
Okay. Is that your understanding of the agreement?
Yes, sir.
2 years confinement in the state jail, that would be suspended. You would be, for 5 years, you would be placed on regular probation. As a condition of probation, you must serve 90 days upfront confinement. You've already served 60.
Yes, sir.
That'd be another 30 days. Restitution would be owed in the amount of $700.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
And that $700 needs to be paid within 30 days after you are released.
Yes, sir.
All right. Again, if I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this state jail felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence.
objection.
Without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this was true. So help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report. Wayne.
Yes, sir.
I'm going to follow this agreement, and if nothing further to add, I'm going to find you pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty to the state jail felony. There's sufficient evidence supporting your guilty plea here from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement term is suspended. You were placed on regular probation for 5 years. There will be terms and conditions of probation which are normal and customary for this type of crime. You must pay restitution in the amount of $700 based upon this loss. In this case, to be paid within 30 days of your release from confinement. You must serve 90 days in the county jail with credit for time served. Will be credited against that 90 days. So you've got 30 more days. There will be other terms and conditions of probation. Please follow these. If you fail to, your probation could be revoked and you could be sentenced up to 2 years in the state jail. You understand what has happened today, sir?
Yes, sir. Thank you, Your Honor.
Work hard and fix this and do better.
And so, the case concludes. Jeremy Phelps pleads guilty and is sentenced to 5 years of probation, with 90 days of upfront jail time, 30 more days after already serving 60. He must also pay $700 in restitution. The judge's final words are a clear directive: go work hard and fix this and do better. This hearing was more than a legal formality, it was an intervention. It was a stark reminder that the justice system isn't just about punishment, but about demanding accountability and offering one more chance for rehabilitation. The question left for the defendant is whether he will finally use it. Thanks for watching.